In this video, we'll start guardianship under Islamic law. So, regarding that, as Fatwai Alamgiri expressed that guardianship of minors' property and person, and regarding person, it is called Hizanat or custody of the minor, and under Rud ul Muhtar, it was expressed that the father is the guardian and he can give the guardianship to his executor. So also the grandfather is the guardian and he can give its power to his executor and the executor to Kaji and the Kaji to his nominees. So also under Fatwa Alamgiri, father is the natural guardian and he can give it to his executor. So also the grandfather as natural guardian can give this power to his executor and the executor's executor also be given by this power by the executor, and the executor's executor can give this power to the Kaji, and the Kaji can give this power to his executor. So, the very types of guardianship under Islamic law are natural guardianship, testamentary guardianship, and guardianship by court. And in connection to the natural guardians, the position of father and mother are not the same as expressed and as we found among all schools of Islamic jurisprudence. And regarding the Sunnis, the father is the natural guardian and his executor. So also regarding Shias, father is the natural guardian and also the grandfather. Then only the executor of the father, then the executor of the grandfather becomes the natural guardian. And this position among the Shias were the views laid down by Prophet Muhammad, and in the very leading case, Gurbaksh versus Rafia Begum in 1979, the Himachal Pradesh High Court held that as mother is not a natural guardian under Islamic law, so she cannot alienate minor's property. And now we'll go to the testamentary guardian. And the very meaning of testamentary guardian as appointment of testamentary guardians among the Sunnis and Shias. So, among the Sunnis, the father is executor, and in absence of the grandfather are the natural guardians, and among the Shias, the father. And if the grandfather is not alive, and the grandfather has the power to appoint a natural guardian, and regarding appointment of mother as natural guardian, both Sunnis and Shias recognize it at two conditions. One is if she has been appointed as a general executor of the will of the minor's father, and the second condition, if the property is solely her and appointment of non-Muslim. And regarding that, the Sunnis approved appointment of a non-Muslim mother but Shias hold such appointment as invalid. A non-Muslim alien's appointment as testamentary guardian is completely null and void by both the school, but a non-Muslim fellow subject called as Jimani is valid by the schools. And now we'll discuss the views of Darul Mutar and regarding Darul Mutar appointment of a minor bondman or slave or a non-Muslim alien may be set aside by the Qazi, but their acts before their removal will be valid, and as it was expressed in Fatwai Alamgiri, appointment of minor or innocent person as guardian is void, and all acts done by them will be held void and as non-effective. In case of appointment of two persons as guardians, the person who fulfilled rules of Islamic law will be the valid guardian. All schools in Islamic law will be held that bad characters are ineligible and all their actions contrary to the interest and benefit of the minor are void, and it was as expressed among all the schools of Islamic jurisprudence. And now we'll discuss regarding the very formalities. So, regarding the formalities, the first one, that the very testamentary document of guardianship must be written or maybe oral, but it must be clear and unambiguous, and the very tester of that guardianship should have the capacity to make such a guardianship, and that tester must be a major and must have sound mind. So the person appointed as testamentary guardian in Islamic law is generally known in different names as Wasi, Amin, or Kam Mukam. And now we'll discuss regarding the very acceptance and non-acceptance of the testamentary guardianship as appointed by a Muslim. So, acceptance of the appointment may be expressed or implied, but refusal and non acceptance may be only with the permission of the court. So, now we'll go to those guardians as appointed by court, and regarding that, in Mohammedan law, in absence of natural and testamentary guardian, the Qazi has the power to appoint any person as guardian of a Muslim minor. As the Shariat Act of 1937 has no provisions regarding guardianship, so the matter is governed under the Guardians and Wards Act 1890, and the very power of the Qazi in India has no power to appoint any person as guardian of a Muslim minor. So the district court has the power to appoint a guardian for a Muslim minor as provided under Section 17 of the Guardians and Wards Act 1890. Section 17 of the Act provides that it may appoint or declare any person as guardian of a minor child's person as well as property wherever it considers it necessary for the welfare of the minor, taking into consideration the age of the minor, the sex of that minor, the wishes of the child, as well as the wishes of the parents and the personal law of the minor. So here regarding very personal law of the minor, as we know, there are two major sects in Islam as Sunnis and Shias. So among Sunnis there are four different sects like the Hanafis, the Hanablis, the Shafi and the Maliks. So among the Shias there are the Jari school, so the Itna Asari school. So the very personal law of that minor will differ from one sect to another and from one school to another. So, to that extent, the court will decide such matters for the child as per the provisions under Section 17 of the Guardians and Wards Act 1890. So, in our next upcoming video, we'll discuss regarding de facto guardian as under Islamic jurisprudence.